The pen was already in my hand when I saw it. Not a typo, not a formatting error. A name. On line 4 of the deed summary, under Purchaser of Record, in clean black serif font, Rochelle Ashford, my mother-in-law. I set the pen down on the conference table, slowly, like if I moved too fast, something would shatter. My husband, I'll call him my husband because that's what he was, for another few months anyway, was sitting to my left. His realtor, a woman named Gwen, who had perfectly blown-out hair and the habit of clicking her pen every 30 seconds, was at the head of the table. And my mother-in-law was there too, which I had thought was strange when we walked in, but my husband had said she just wanted to be here for the moment. I had smiled at her. She had smiled back. That was 8 minutes ago. Now I was staring at her name on a document I was about to sign to transfer $840,000 out of my personal savings account. Sweetheart. My husband put his hand on my arm. Light, practiced. It's a formality. We talked about this. We had not talked about this. We had not talked about this. I need to back up because none of this makes sense without context, and the context matters. My name is Ivy. I'm 31. I'm a licensed occupational therapist, and for the past 4 years I've also been running a small but growing practice out of a rented suite in suburban Cincinnati. 2 therapists under me, a full patient roster, a wait list that had just hit 60 people. I built it from nothing. From a folding table in a spare bedroom and a business license I paid for with birthday money from my grandmother. I had been careful with money my entire adult life. Emergency fund. Retirement contribution starting at 23. No car payment, no credit card debt. By the time I met my husband, I had just over $1 million in liquid savings, most of it from a combination of my practice income and a life insurance payout after my father passed when I was 27. That money was sacred to me. It was my dad's last gift. I didn't touch it carelessly. I met my husband. I'll call him Kent because that's his name, and he doesn't deserve a pseudonym, at a fundraiser for a pediatric rehab center where I had volunteered for 3 years. He was charming, funny. He asked smart questions about my work, remembered details from our first conversation when he texted 2 days later, and showed up to our 3rd date with a book he'd bought because I'd mentioned it in passing. The kind of thoughtful that feels intentional in a good way. He was a contractor. Residential renovations, mostly kitchens and bathrooms. He made decent money, not great money. That was fine. I wasn't looking for someone to fund my life. We dated for 2 years. He was kind to my friends, patient with my anxiety, good with my younger sister's kids. I loved him. I want to be clear about that, because what comes later might make it sound like I was naive or stupid, and I wasn't. I was just in love with someone who had been lying to me from the beginning. We got married in September. Small ceremony, backyard, 30 people. His mother in the front row wearing a dress the exact same shade of ivory as my gown. I noticed it. I let it go. His mother, Rochelle, had never warmed to me exactly, but she was never outright cold either. She asked careful questions about my practice in a way that felt like due diligence rather than interest. She remembered my coffee order but forgot my sister's name twice. I had filed her in the category of not my favorite person, not a problem. That was my first mistake. 8 months into our marriage, Kent came to me with an idea. The practice was doing well. My landlord had just told me he was selling the building, which meant I either needed to find new space or buy him out. We sat at the kitchen table with takeout and spreadsheets, and he walked me through what he presented as a straightforward option: buy a condo unit 2 miles away that was zoned for medical office use, move the practice there, build equity instead of throwing money at rent. The asking price was $840,000. With my savings and a small commercial loan, it was doable. Tight, but doable. It would be yours, he said. Your practice's asset. We don't even have to put my name on it. That struck me as generous at the time. I spent 3 weeks thinking about it. I talked to my accountant, my attorney, 2 colleagues who owned their spaces. Everyone said the same thing: good building, good location, fair price, solid move for a practice at my stage. I said yes. Gwen, Rochelle's longtime friend, I would later find out, though nobody thought to mention this, handled the listing. Kent handled coordinating the paperwork. I was busy with the practice, with the staffing change, with the kind of daily operational chaos that makes you grateful when someone offers to handle the logistics. I reviewed documents when they were sent to me. I asked questions. I signed what I was told to sign in the early stages. I did not read page 4 of the closing packet before the day of closing. That is something I will never forgive myself for, even now, years later, when I understand exactly how the trap was built and exactly how much effort went into making sure I wouldn't look too closely until it was too late. I still think I should have looked. I should have read every word. The morning of closing, I woke up before my alarm, made coffee, sat at the kitchen table and felt something that was mostly excitement and a little bit of nerves, which is normal when you are about to spend the better part of $1 million. Kent was already dressed when I came downstairs. He seemed, I know this now, slightly too energetic, like someone who had rehearsed their calm. We drove separately because I had a patient appointment after. He was already in the conference room when I arrived, along with Gwen and her clicking pen and Rochelle, who was holding a paper coffee cup and smiling at me like we were at a birthday party. Mom wanted to be here, Kent said before I could ask. Of course, I said, because what else do you say? I sat down. Gwen pushed the packet across the table. I started reading from page 1, which is what I always do, which Kent knew I always do, which is probably why the conversation at the table was designed the way it was. Rochelle asking me questions about the renovation timeline, Gwen chiming in about permit schedules, Kent nodding along. The three of them creating just enough ambient noise to break my concentration every 45 seconds. I made it to page 4. I read the line. I read it again. Rochelle Ashford, purchaser of record. I put the pen down. I need a minute, I said. The table went quiet in a specific way, not the quiet of people giving you space, the quiet of people who were waiting for this. Kent. I kept my voice even. I had learned, growing up with a mother who cried at confrontation, that the most effective thing I could do in a moment of crisis was stay completely flat. Why is your mother's name on this deed? He had an answer ready. He'd had it ready for a while, I think. He said it was a tax strategy. Something about how Rochelle had a different ownership structure that would reduce the property tax burden, how it was just on paper, how we would transfer it to my name after 12 months once certain thresholds were met. He used words like stepped-up basis and depreciation schedule and estate planning benefit. You're not buying a rental property, I said. This is my practice's primary asset. It's the same principle. It's not the same principle. Ivy. Gwen's voice was smooth. Professional. This is actually a fairly common structure, especially for I'm sorry, I said. Are you my attorney? She stopped clicking her pen. I'd like to speak to my husband alone, I said. Rochelle stood up slowly the way older women do when they want you to notice how inconvenienced they are. She and Gwen moved into the hallway. I could see them through the glass wall of the conference room. They stood close together. They were not surprised. They were waiting. What is actually happening right now? I asked Kent. He reached across the table and put his hand over mine. His eyes were soft. I had trusted those eyes for 3 years. I'm protecting us, he said. This is a smart move financially. I wouldn't do anything that wasn't good for you. Then put my name on the deed. We will. In 12 months. Now. Something shifted in his face. Just a fraction, like a mask adjusting. It doesn't work that way. The whole structure falls apart if. Then the structure falls apart. He leaned back. When he spoke again, his voice was different. Still controlled, but with something harder underneath it. You're being emotional. This is a business decision, and you're treating it like a personal attack. That word, emotional. I had heard him use it before, in smaller ways, in smaller arguments. It had always made me doubt myself. It didn't, this time. This time it clarified something. I stood up. I picked up the packet. I said, "We're done here," and I walked out. He caught up with me in the parking lot. He was calm again, back to soft-voiced and reasonable, and he told me I was overreacting, that his mother was just trying to help, that I would understand once I talked to a tax attorney. He said he had been trying to surprise me with a smart financial structure, and I had made a scene in front of Gwen, who was a professional and a family friend. I drove home. I sat in my car in the driveway for 20 minutes. Then I called my attorney. Her name is Audra. I've worked with her since I opened the practice. She is one of those people who speaks in complete sentences even when she's angry, which is how I knew, 40 minutes into our phone call, that she was very angry. He doesn't have your power of attorney, she said when I finished explaining. He couldn't have changed the deed without your signature on the original contract. I signed a lot of things during the offer stage. Send me everything. I spent the next 2 hours photographing every document I had received in connection with this purchase. Emails, countersigned addenda. The early draft of the purchase agreement I had reviewed back in November. Audra called me back at 7:30 that evening. On page 9 of the November draft, she said, there is an addendum. Paragraph C, subsection 2. It's written as standard tendum. Paragraph C, subsection 2. It's written as standard title vesting language. It is not standard. Someone added a clause that designated a co-trustee authority to the named purchaser's family member in the event of a tax classification election under a specific code section. She paused. It's buried. I almost missed it. What does that mean in plain English? It means someone, probably an attorney, possibly Gwen working with one, drafted language that made the substitution of Rochelle's name appear contractually authorized by something you signed. It's designed to look like a tax filing decision you pre-approved. Another pause. Ivy, this is not a tax strategy. This is deed fraud. I sat down on the kitchen floor. I don't know why the floor specifically. It just seemed like the right place to be. Can I fix it? We can fight it, but I need to ask you something. Do you have access to Ken's email? I didn't. But I knew his laptop password because we shared a Netflix account and he'd written it on a sticky note 18 months ago that I had never had reason to use. I don't want you to do anything illegal, Audra said carefully. But if you find anything relevant, you know where to find me. I want to be clear about what I felt that night. It wasn't rage. It wasn't even sadness, not yet. It was a very specific kind of cold clarity, the kind that comes when you realize the map you've been using is wrong and you have to figure out very quickly exactly where you actually are. I did not touch his laptop that night. I went to sleep, or tried to, and I thought about every moment in the last 8 months that had felt slightly off. The way he'd insisted on using Gwen specifically. The way Rochelle had come to every walkthrough which I'd attributed to her interest in real estate. The way Kent had always been in the room when I reviewed documents, always with a comment or a question that pulled my attention at exactly the right moment. This had been planned. Not impulsively, not opportunistically, planned. Months of planning. For what? To put an $800,000 property in his mother's name, funded entirely by my savings. And then, what? Transfer it to herself? Sell it? Keep collecting from my rental payments to my own practice space until I figured it out? I thought about the email address I had used for all the closing correspondence. It had been set up through Gwen's transaction portal. I had never questioned it. I went back through my inbox and found the activation email from 6 months ago. The portal email was Ivory's practice transaction at doc2close.net, a third-party address I had never controlled. I called Audra in the morning. She told me to print everything and bring it to her office. What Audra found over the next 10 days is, in her words, one of the more thorough small-scale fraud schemes she had seen in 20 years of practice. Here is what had been built. The transaction portal had been set up in my name but administered by Gwen's office, which meant that any document sent to me for review could be intercepted, modified, and resent before I ever saw it. The addendum on page 9 of the November draft had been inserted into a revised version of the contract after I had reviewed the original. The signed copy in Gwen's files reflected the revision, while the copy in my email showed the original. Someone had swapped them after the fact, and had been sloppy about the metadata. Rochelle had opened a home equity line of credit 3 months earlier using a different property she owned and had listed a pending real estate acquisition as the purpose. She was planning to use my purchase as collateral. The plan, as best as Audra and I reconstructed it, close the deal with Rochelle on the deed, have me pay the mortgage as rent for my practice space, eventually refinance using the property's equity with Rochelle as the owner. And by the time I realized what had happened, if I ever did, the money would be tied up in a financial structure that would take years and significant legal fees to untangle. They had done the math. They knew my savings, my income, my practice's revenue. Kent had access to all of it. He had known when we started dating what I was worth. I thought about the fundraiser where we met, whether it had been a coincidence that he was there, whether anyone had pointed me out. I still don't know the answer to that. Audra filed a complaint with the county recorder's office and a civil fraud action within 2 weeks. She also referred the matter to the Ohio Attorney General's office, which handles deed fraud cases, and to the State Real Estate Licensing Board regarding Gwen. I did not tell Kent. I kept going to work. I came home. I made dinner. I smiled and I answered questions, and I slept next to a man who thought I had calmed down and come to my senses because he had decided I was emotional and not particularly dangerous. That was his mistake. The morning the investigator from the AG's office requested a formal interview with Kent and Rochelle, which Audra had coordinated to happen simultaneously, so neither could warn the other, I was at the practice in my first session of the day, watching a 7-year-old practice zipping up her jacket. Audra texted me at 9:47, both made contact with investigators. Rochelle's HELIC has been flagged. Gwen's license is under review. You're clear. I finished my session. I took a breath. I went to my next patient. Here is what happened afterward. In the order it happened, Kent was charged with 1 count of deed fraud and 1 count of conspiracy to commit financial fraud. His attorney negotiated a plea. He was sentenced to 30 months. Rochelle was charged separately. The AG's office considered her the primary architect, which she was, with deed fraud, financial exploitation, and conspiracy. She received 42 months. The judge noted during sentencing that the scheme had targeted a family member through a position of trust, which the court treated as an aggravating factor. Gwen lost her real estate license. She settled a civil suit with me for an amount I'm not allowed to disclose. The property was never transferred to Rochelle. The sale was voided. I eventually purchased a different space, a smaller unit 2 blocks away, in my name, reviewed by 3 attorneys, with a notary present who had no connection to anyone I'd ever met. I filed for divorce the same week Kent was arraigned. He didn't contest it, probably on legal advice. The settlement was straightforward. We had kept our finances largely separate, which meant there was less for him to claim than he had apparently anticipated. That miscalculation was, in retrospect, what made the condo scheme so important to them. My money was harder to access than they had planned for. His mother is currently serving her sentence at a minimum security facility in central Ohio. People ask me sometimes. Friends, my sister, once a journalist who reached out after the case was covered in a local business publication, whether there were signs, whether I should have known. And the honest answer is, yes, there were signs. The too perfect thoughtfulness in the early months of dating, the kind that looks like attentiveness and is actually information gathering. The way he was always slightly more interested in my financial decisions than in my day. The way Rochelle asked careful questions about my practice's revenue at our first Thanksgiving dinner, and I had thought she was just a woman who expressed interest through logistics. The way at the closing table, when I put the pen down and said I needed a minute, the 3 of them went quiet in that specific way, not surprised, waiting. That moment. I replay it sometimes. Not with regret exactly. I did put the pen down. I did ask the question. I did walk out. But I replay it because I want to understand how I got to that table in the first place. How someone can know you well enough to love you convincingly and simultaneously be calculating exactly how much you're worth. I don't have a clean answer. What I have is this. I rebuilt. The practice is still running. The new space has better light. My patients don't know what happened, and I prefer it that way. My dad's money is still in my account. Most of it. The legal fees were significant but manageable, and I think if he had known what it took to protect it, he would have said it was worth it. I think about him sometimes when I'm locking up the office at the end of a long day, the way he used to say that the most dangerous thing you can give someone is unconditional trust. That trust should always have conditions. That love is not the same thing as proof. I was 31 years old and I thought I knew the difference. I do now. I've thought a lot about what made this possible, not the legal mechanics. Audra explained those clearly enough. I mean the human part. The part where a person sits across from you at a dinner table for 3 years, asks about your patients, remembers how you take your coffee, and is simultaneously running a calculation in the background about how to redirect your life savings into his mother's name. What I keep coming back to is this. Kent and Rochelle didn't fail because they were unlucky. They failed because they underestimated what it actually means to build something from nothing. When you spent years earning every dollar carefully, working late, making hard calls, saying no to things you wanted because the business needed it more, you develop a kind of attention that other people can't always see. It doesn't look like suspicion. It looks like calm. But underneath it, you know the weight of what you've built, and you notice, on some level, when someone is treating it carelessly. I noticed something was wrong the moment I saw Rochelle's name on that deed. I didn't have language for it yet. I didn't have proof. But something in me, the same part that had read every lease before signing, that had asked hard questions of every contractor, that had built a practice from a folding table, that part put the pen down. That's the thing about integrity. Not the word people use in speeches, but the real version, the functional version. It's the practice of staying consistent with what you actually know to be true, even when someone is standing in front of you using calm words and soft eyes to tell you that you're wrong. Kent called me emotional. He said I was making a scene. And I felt, for just a second, the old pull of self-doubt, the question of whether I was overreacting, whether I was being difficult, whether I should just trust the person I loved. I didn't, not because I was fearless, but because I had learned, through years of running a business, that doubt is not the same as being wrong. You can feel uncertain and still act on what you know. That's not stubbornness, that's discernment. Rochelle is serving 42 months. Kent is serving 32 months. Kent is serving 30. Gwen lost her license. And I own a smaller office 2 blocks from where that closing was supposed to happen, reviewed by 3 attorneys, in my name with better light. The money my father left me is still mostly intact. There's a version of the story where it isn't, where I signed on page 4 without reading it, or where Kent's voice was steady enough to talk me back to the table. That version exists. I lived close enough to it to feel it. What I want people to understand, especially anyone who's ever been called too careful, too serious, too much, is that those qualities are not flaws. The same discipline that looks uptight at a dinner party is what keeps you from losing everything at a closing table. The same habit of reading the whole document is what catches the thing on page 4 that someone buried there, hoping you wouldn't. Ivy put the pen down. That's all. One small act of trusting what she already knew. Everything that followed came from that moment. The call to Audra, the discovery, the investigation, the case, the sentencing. One pen set down on a conference table in Cincinnati. The rest was just consequence.